A very good morning, everyone. I welcome you on behalf of Legal Specs and myself to the last session, uh, that is session 8 of this M&A workshop. Today, we shall be covering not a very complex set of topics, to be very honest, which is looking at key Indian legal reforms. We're looking at cross-border headwinds and key global M&A trends. And we're also looking at what lies ahead in terms of anticipated legal evolutions. We shall be touching upon competition, SEBI, data privacy, FEMA, ESG, tech, etc. So let me just quickly share my PowerPoint presentation and let's get started. Right. I hope my screen is visible to everyone. I hope my screen is visible.
Yes, sir.
Okay, thanks, Shreyanshu. Okay, so let's firstly look at impact of digitalization on AI and AI on M&A transactions, right? So the impact of digitalization and artificial intelligence on M&A has been, in my opinion, transformative, and it also has reshaped how deals are identified, executed, and even integrated. So from perhaps automating due diligence to improving post-merger integration, digital tools and AI are reducing costs, they're mitigating risks, and they're also speeding up deal cycles. So let's look at what aspects have actually brought about this transformation, right? So firstly, you can understand the deal sourcing and target identification have become more efficient because you now have two things, which is AI-powered market intelligence and digital platforms and data aggregators. So when it comes to AI-powered market intelligence, advanced analytical tools and machine learning algorithms can scan thousands of market indicators, financial metrics, and industry developments to identify promising targets that align with a buyer's strategic goals. So tools like predictive analytics use historical M&A data and trends to suggest potential synergies and acquisition opportunities. When it comes to digital platforms and data aggregators, you have platforms like PitchBook, CD Insights, and Crunchbase, enhanced with AI to provide real-time deal flow and also computer benchmarking. I mean, when I say real-time deal flow, I meant real-time deal flow tracking, like updates. And also, it enables acquirers and advisors to spot trends on and emerging players faster than before. The second avenue where it becomes like helpful is risk assessment. So again, under this, understand three things. Firstly, when it comes to document review and NLP tools. Second is when it comes to cybersecurity diligence. And third is real-time data rooms. So due diligence is traditionally, as you know, a very time-consuming process. So AI-enabled tools like Kira systems, Luminance, and eBravia use natural language processing to scan large volumes of contracts, compliance records, and financial documents to flag issues, obligations, change of control clauses, and even hidden liabilities. As far as cybersecurity diligence is concerned, I think now what we see is an increase in digital integration. So if you assess a target cyber maturity, uh, it becomes more crucial, right? So AI tools can detect vulnerabilities, data privacy compliance gaps, and past breaches, which helps acquirers understand digital risk exposure in real time. So that said, I think the question that then arises is, since there is a lot of expedient data processing, how about the storage of data? So initially, I mean, you can understand that data rooms, if printed, if created via print media, can occupy like rooms together. So we've shifted to virtual data rooms. Now again, there's a memory crunch issue that arises. So now we are like with AI and digitalization, virtual data rooms have evolved into a dynamic digital platform with AI-assisted search, tagging, and access control, which allows for more efficient information exchange between parties and advisors. The third aspect where this has become helpful is valuation and financial modeling. So again, under this valuation and financial modeling, there are two aspects that we have to look at. First is the automated forecasting, and second is the scenario simulation. So when it comes to automated forecasting, understand that AI and robotic process information, robotic process automation can generate what we call dynamic financial models that incorporate multiple things that were really required from a deal perspective, such as macroeconomic trends, industry data, and historical performance. So these tools increase valuation precision and they reduce analyst bias. So what that said, how exactly does this transform into implementation towards day-to-day diligence purposes is what is a question that everyone would have. So for that, excuse me, we can understand scenario simulation. So understand that AI systems can run multiple what if simulations to evaluate the financial impact of different acquisition strategies, market conditions, or regulatory changes. So this enables more data driven and risk sensitive decision making. Then comes your then again where it comes useful is negotiation and contract management. I think as easier said than done here. Contract analytics and clause comparison is something that AI can help with, and smart contracts is something that AI can help with. These respectively mean that AI tools can benchmark clauses against databases of historical agreements to identify deviations or missing protections. For example, tools like Thought River and Lex Check, I'm just giving you examples. They assess clause level risk scores, improving negotiation preparedness. So smart contracts, on the other hand, is like where you have tech-driven deals, blockchain-based smart contracts, which are being used to automate post-closing conditions like escrow release or earnouts, and hence improving transparency and reducing disputes. Then comes regulatory compliance and ESG alignment, very important. Again, you have two aspects here. One is AI-powered compliance screening, and second is ESG data integration. Uh, when it comes to AI-powered compliance screening, acquirers are now using AI to screen targets for compliance with anti-corruption sanctions, environmental and human rights obligations, especially in cross-border deals. So this includes automated due diligence to supply chain ESG compliance using AI-enabled tools. When it comes to ESG data integration, which is the second utilization of AI and digitalization from an ESG compliance perspective, understand that digital platforms increasingly integrate ESG into target evaluation. So AI algorithms score companies on sustainability risks, enabling acquirers to avoid what we call brown assets, or that is litigation prone assets or litigation prone operations rather, aligning M&A with long-term value creation. The next utilization is, of course, with your post-merger integration under three aspects. First, cultural and operational mapping. Second, workflow automation. And third, real-time KPI tracking. So AI tools can analyze internal communications, organization charts, and performance metrics to assess cultural fit and identify potential friction points, which enables smoother integration planning. The second is workflow automation, where digitalization facilitates seamless integration of IT systems, HR platforms, and supply chains. So AI bots can automate onboarding, data migration, uh, payroll harmonization, and even talent retention strategies. Then comes your real-time KPI tracking, which is your real-time key performance indicators tracking, wherein your post-deal dashboards powered by AI offer live tracking of key integration KPIs, which include um, cost synergies, revenue, growth, and churn, allowing leadership to which allow leadership to perhaps course correct uh, faster if integration is falling short. Let me put it that way. Then comes like certain challenges and risks that you have to be aware of. So first is over reliance on algorithms. That is, heavy dependence on AI can really destroy human judgment, especially in cultural or strategic alignment assessments. Your second is bias and data quality issues, wherein AI tools are only as good as the data fed into them, and incomplete or biased data sets can like completely harm the due diligence or valuation results. Then comes your cyber risks, because increasing use of digital tools makes sensitive deal data more vulnerable to cyber threats if it is not properly secured. And lastly, your regulatory scrutiny bit, wherein use of AI for automated compliance can raise issues if it fails to identify critical violations or if regulators question the methodology. So this is the end of the first part of the lecture. Does anyone have any questions before we move on? I mean, it's a fairly simple topic, so I understand if there are no questions. But if you have even the slightest of doubts, you can feel free to ask. If you want me to repeat anything, please feel free to ask me. Okay, take that as none. Let's move on. So ESG considerations and sustainable M&A practices is our second topic for today. So in recent years, ESG factors have emerged as a central pillar in shaping M&A strategies globally. And investors, regulators, and consumers are increasingly scrutinizing not just what companies do, but how they do it. So considering consequently, I think ESG side considerations are no longer peripheral, but they're intrinsic to the assessment, execution, and integration phases of mergers and acquisitions. And therefore, sustainable mergers and acquisitions are now regarded as a uh, uh, perhaps, I don't know how to put it here. Uh, Strategic imperative that enhances long term, you can say, value, mitigation of reputational risk, and future proofs transactions against evolving regulatory expectations. So your first consideration here is ESG as a strategic driver for M&A. So M&A activity is increasingly being driven by ESG focused objectives, and acquirers are pursuing targets that can accelerate sustainability goals, add ESG capabilities such as clean tech innovations, ethical supply chains, or inclusive governance structures. Uh, and also perhaps actually no also for that matter strengthen brand equity by aligning with values around social responsibility and climate resilience. Now, by way of example, large corporates are acquiring renewable energy startups or companies with strong diversity and inclusion records, not just to satisfy regulatory metrics but also to reshape public perception and drive responsible growth. Then comes your ESG due diligence and risk assessment. Over here, again, it's a three-pronged consideration. First, environmental diligence, which is evaluating the target's carbon footprint, water usage, hazardous waste management, and climate change risks. Second is social diligence, wherein you would scrutinize labor practices, community impact, workplace safety, and human rights compliance, particularly in global supply chains. Then comes your governance diligence, wherein you would assess board diversity, uh, executive compensation, anti-corruption policies, and data privacy standards. So this form of ESG due diligence goes beyond mere checkbox compliance, and it focuses on identifying hidden liabilities such as pending environmental lawsuits and exposure to regulatory risks or reputational risks from social misalignment. Then comes your ESG linked valuation metrics, wherein you can understand that sustainability characteristics are now influencing valuations in tangible ways. Companies with high ESG ratings often command premiums due to their resilience and lower risk profiles. And conversely, targets with poor ESG track records may face valuation discounts or may even be excluded from consideration by ESG focused investors or funds. Then you have your analysts that are incorporated carbon pricing, uh, regulatory costs, and transition risk factors into financial models um, to predict the long-term value implications of ESG performance. So basically, this shift has led to the emergence of new valuation metrics, uh, like sustainability adjusted EBITDA and green revenue share, which quantify how ESG performance impacts business fundamentals. Then comes integration of ESG post-acquisition. So sustainable M&A practices don't stop at closing. ESG considerations play a major role in post-merger integration because of three aspects. First is sustainability harmonization, that is aligning ESG policies and sustainability goals across combined entity. Uh, and which could ultimately include adopting unified emission targets, ethical procurement standards, or new whistleblower mechanisms within the combined entity. That is like resultant entity that is created as a combined entity in furtherance or in pursuance of that transaction. Then comes your stakeholder re-engagement, wherein you are communicating ESG progress to stakeholders, investors, employees, regulators, and communities, which is key to maintaining trust and legitimacy. And you also have a retention and culture, wherein mismatched ESG cultures can lead to talent attrition or employee unrest. And integration planning is increasingly in consideration of the social values and governance practices of both organizations. So leading acquirers or use ESG scorecards during post-merger integration to track progress on environmental goals, social cohesion, and compliance governance. Then comes your regulatory and reporting landscape, wherein you have to understand that the regulatory environment is evolving rapidly and which is mandating ESG integration into M&A transactions. Let me take the example of two jurisdictions and give you some global examples. Let's take Europe and India, and then let's go to a bit global. So in Europe, you have the CSRD, which is the Corporate Sustainability Reporting Directive, and the EU taxonomy, under which companies need to disclose how acquisitions align with sustainable activities and affect ESG KPIs. In India, you have the BRSR framework, which is the business responsibility and sustainability reporting framework of SEBI, which requires ESG disclosures for the top 1,000 listed companies in the country. And this is now indirectly shaping M&A diligence and integration for listed acquirers. From a global perspective, you have the climate-related disclosure frameworks such as TCFD, IFRS S1, S2, and ISSB standards, which are being adopted across jurisdictions, prompting buyers to include ESG data and climate resilience indicators in their M&A documentation. So failure to consider ESG compliance in cross-border transactions can expose acquirers to fines, loss of investor confidence, and post-deal restructuring costs. Then comes your sustainable financing and ESG-linked deal structuring, wherein ESG considerations can be understood to also impact how deals are financed. For that matter, let's look at three things again. First, green M&A financing. Second, earnouts and KPIs. And third is your governance. So as far as green M&A financing goes, understand that deals are increasingly being financed through green bonds or sustainability-linked loans with interest rates tied to the acquirers or targets ESG performance. As far as earnouts and KPIs go, understand that ESG-linked earnouts are becoming more common, where a portion of the purchase price is tied to the target achieving post-closing ESG milestones, like lowering emissions or improving board diversity. Then comes your governance, where ESG governance are embedded in acquisition agreements to ensure alignment on future sustainability actions and disclosures. You then look at your litigation and reputational risks, wherein you have to understand that ignoring ESG can expose buyers to litigation risks, particularly in sectors under environmental or social scrutiny, and misalignment between the acquirer's ESG commitments and the target's practices can A, trigger investor activism or shareholder backlash, B, lead to regulatory probes or enforcement actions post-acquisition, C, damage long-term brand value and consumer trust. For example, cases of post-M&A human rights violations or emissions breaches have led to share price drops or class action suits in the past. Let's then come to, okay, let me pause and ask if there are any questions before we come into the recent trends. Well, don't have to worry about the study material after the session today, which Anshu will be sharing a consolidated study material that I have prepared. which I think Shriyanshu will forward to your group. It's basically a compilation of all of the relevant information from our previous sessions, which you can go through for a brief understanding, and then you can join the. I mean, you can view the recordings as and when you might need. But yeah, are there any questions? Okay. Seeing that there are none, let's come to the last part of today's lecture. So recent reforms and future legal developments in M&A is what we shall now be looking at. So the legal landscapes governing M&A is undergoing rapid transformation, according to me. I think, for that matter, both uh, I think both within India and globally, to safely to say, which are driven by shifting regulatory priorities, heightened antitrust scrutiny, ESG imperatives, and the digitalization of corporate governance. So I think it's safe to say that as deal volumes rebound post-COVID and strategic consolidation continues across sectors, legal reforms have aimed at increasing transparency, improving compliance, and addressing emerging market realities. So this evolution reflects both local legislative initiatives and global policy trends that will define the future of M&A transactions in the country. Uh, So again, in India, you had the CCI Amendment Act of 2023 for deal value thresholds, wherein India's Competition Amendment Act introduced a deal value threshold to bring high value transactions under scrutiny, even if the target has limited Indian assets or turnover. So you had a threshold that was introduced wherein deals exceeding 2,000 rupees, INR 2,000 crores in value and involving a sustainable business operation in India must now be notified to the Competition Commission of India. You also had an objective that it is to capture digital technology and pharma deals like Facebook, WhatsApp, which previously escaped scrutiny due to low revenue. Then is your timeline, which was brought about, wherein implementation awaited through formal regulations, which clarified sustainable business operation. Then in India, again, you also had this bit of faster M&A approvals, wherein the 2023 Amendment Act also introduced a reduced review timeline, wherein CCI must form a prima facie opinion within 30 calendar days, which was down from 30 working days, and an overall clearance within 150 calendar days. Then you also had a green channel route, which was still available for combinations with no horizontal or vertical overlaps, but may be replaced or updated in future regulations. Then comes the SEBI regulatory changes for listed companies, wherein SEBI introduced multiple reforms to enhance transparency in M&A transactions involving listed entities. So again, you had three things under this. First is your independent valuation. Second is delisting after schemes of arrangement. And third is the SPAC framework. So under independent valuation, there was a strengthening of valuation norms for related party transactions and delistings. Under delisting after schemes of arrangement, there were tightened norms under the SEBI delisting of equity shares regulations of 2021. Excuse me. And under SPACs, SEBI had signaled interest in developing a framework for SPACs, aligning with global trends in alternative M&A structuring. For those of you who don't know what SPACs are, these are special purpose acquisition companies. I'm sorry, I'm just quite used to calling them SPACs, so I inadvertently missed out on giving you the full form. So in India, again, you also have the DPDPA of 2023, I think, which is the next point on the slide. I'm not wrong. Yeah, the last one. Second one, sorry, my bad. Second point, second head, second subhead, second point. What happened? Yeah, it's here. So how do I put this? Let me think of how to put it simply to you. So if M&A deals are involving digital assets or customer data, which they now require diligence under the DPDP Act 2023, which imposes one, consent-based processing data processing obligations, two, penalties for breach up to rupees 250 crores per instance, and three, cross-border data transfer restrictions. So the implication is that M&A transactions involving tech, finance, and health sectors must now assess data compliance risks and cybersecurity liabilities more seriously. Then comes your cross-border M&A and FEMA regulations, which basically indicate the liberalized remittance scheme and the automatic route for foreign investment. So the liberalized remittance scheme has been tightened to prevent misuse in offshore M&A funding, and at the same time, automatic route for foreign investment is expanded to include certain defense and insurance-related transactions, easing cross-border M&A. Coming to the global trends, first, let's look at again the competition concerns. Second, let's look at foreign investment concerns. Third, let's look at ESG. So again, from when it comes to competition concerns, it's mostly heightened antitrust security. So let's look at US, EU, and UK, because I mean these are the most happening jurisdictions when it comes to these things. So in US, under the Biden administration, the Federal Trade Commission and the Department of Justice have adopted a more aggressive approach to M&A scrutiny, especially in tech, pharmaceuticals, and private equity roll-ups. In the EU, the European Commission's Article 22 referral mechanism allows scrutiny of deals below EU thresholds if they threaten competition in any member state. Then comes UK, wherein post-Brexit, the UK Competition and Markets Authority has increased enforcement and also in furtherance of the same reviewed deals with potential for data monopolization. Then comes your foreign investment controls and national security reviews. Then countries are expanding FDI controls to protect national interests. And in India, restrictions on investments from countries sharing a land border with India, like especially China, remain in force. Sorry, it was the worst example I could give, but that's what came to my head. In the US, the CFIUS continues to block deals with foreign entities in sensitive sectors. I mean, considering the recent situation that's going on, I mean, Iran would be an ideal example to take when it comes to national security for the US. And EU, of course, mandatory notification regimes for foreign investors in strategic sectors like energy, telecom, AI, and semiconductors. As far as ESG is concerned, so you can look at the CSRD for the EU and the IFRS S1 S2 standards, which are reshaping disclosure obligations in cross-border M&A deals. And buyers must now report how acquisitions affect their sustainability goals. As far as buyers go, buyers must now report how acquisitions affect their sustainability goals and expect increased adoption of ESG-related linked earnouts, KPIs, and covenants in deal documents. As far as digital taxation and transfer pricing go, the Organization for Economic Cooperation and Development has this pillar 2 global minimum tax, which is 15% on large M&Es, which is being adopted across jurisdictions from 2024 onwards, which will affect your holding company structures, location of IP and services, and post-merger tax efficiency planning. Then comes your anticipated future legal developments, right? So in India, we're looking for something called a draft merger control guidelines. And this was in the news. I don't know how much of development this has been there that has been on this, but this is expected in 2025, when the CCI is expected to issue comprehensive guidelines on merger assessments, thresholds, and safe harbors, which bring more predictability to the filing process. Then come and like also, I think before I move on to SPACs, I'd also like to highlight that these guidelines may clarify the treatment of minority acquisitions, private equity roll-ups, and non-controlling acquisitions with strategic influence. As far as SPACs go, understand that while Indian companies have participated in overseas SPACs, there is no domestic legal framework. So SEBI is expected to release draft regulations to A, permit SPAC listings in India, B, define timelines for de-SPAC transactions, C, introduce investor safeguards and lock-ins. Then comes your artificial intelligence in M&A, wherein regulators may soon begin scrutinizing algorithmic collusion, automated pricing, and data concentration in M&A involving AI platforms. You also in the EU, you have something called the EU's Digital Markets Act and the AI Act, which will impact M&A in the tech and data economy, especially for gatekeeper firms. You then have your sustainability linked M&A instruments, which will expect greater formalization of ESG linked debt instruments, green performance bonds, and sustainability based indemnities. You then have legal documentation, which will likely evolve to include third party verification of ESG KPIs and enforceable ESG compliance undertakings. Lastly, you have tech and data-driven competition law reforms, wherein India, UK, and Australia are studying frameworks to assess data dominance and platform neutrality in M&A. And you also have to note, for that matter, or understand, how do I put this in? I really don't want to use complicated language. Please give me a minute. Let me break it down to you simply. Yeah. So these can result in revised merger notification forms, which will all include new parameters like data ownership, AI training sets, and algorithms as competitive sets. So I guess this is all I had to cover for today. It wasn't a very expansive session considering the limited scope of the topics. But yeah, I will be happy to take questions if any. I'll also meanwhile screen share and show you the material I've prepared, which I'll be sharing with Shriyanshu.
Sure, sir.
Yeah. So just give me a minute. Meantime, if there are any questions, you can unmute and ask. Not only about today's session, about anything in the last 8 sessions. This is the last time we're meeting. So in from the last 8 sessions, if there are any questions, you can really feel free to ask me. You have we have 26 minutes, which is a lot of time. Where did this go? Sorry. Sorry, 1 second. Yeah, yes, Barha, if I'm pronouncing it correctly, you can. Let me just quickly share the material with you. So, yep, this is the Word document version. I'll obviously be sharing a PDF. Is it visible?
Yes, sir.
Great. So, yeah. This is how it looks. You start with an overview. We get into key types. We look at economic and legal considerations. We then go down into corporate laws. We then come down, and it's just a primer material. So you have something to read if you want to revisit any session. Then foreign investment regulations. Then you have tax implications. Then you have due diligence in M&A transactions. Then you have structuring M&A transactions. Then you quickly have your drafting key M&A agreements. Uh, then comes your negotiation strategies and deal execution. Then you have your post-merger integration and challenges. Um, then you have emerging trends and M&A law. So it's not a very how do I put this, bulky material, because it's a primer material, so it's only like 16 pages. But this should be like good enough to give you a quick insight into really understanding what exactly has been covered in these sessions, and it will also be good enough for you to really make sense out of any recording that you are viewing. So I will, like, right after the session, I'll drop it to Shriyanshu on WhatsApp. Shriyanshu, I hope that's okay, and you can then forward it to them.
Yes, sir. Completely fine.
Right. Okay. Priyanshu, I don't think there are any other questions, unfortunately. We'll have to end this here. Over to you.
Okay, sir. So I would sincerely thank you for all your efforts over the last 2 months that you have given to legal specs. So it
Mhm.
has been a great journey with you to cover the basics of M&A, delving into the what future beholds for mergers and acquisitions. So I really thank you from the side of legal specs, from all the participants, and especially Team Legal Specs, those mentored, who have been mentored by you have been greatly benefited. Thank you so much, sir. Thank you.
Thank you so much, Jianshu. I'm dropping my number on what on the text box. Uh, if anyone